Thank you for accessing the public charge presentation. This presentation is brought to you by the DuPage Federation on Human Services Reform and is funded by support from Protecting Immigrant Families. My name is Kristin Hartsaw, and I am your presenter today. I work for an organization called the DuPage Federation on Human Services Reform. We are a small nonprofit organization based in DuPage County, but our work goes beyond that geographic boundary, and we find ourselves doing work regionally and statewide. My role at the Federation is Director of Training and Technical Assistance. In this role, I provide training to social service providers on public benefits eligibility, application, and processes. For the past several years, we have been providing training on the immigrant eligibility rules for accessing public benefits, which is how we came to be one of the steering committee members of Protecting Immigrant Families Illinois, and why we are doing training on public charge. This presentation will provide a detailed overview of the Public Charge Inadmissibility Rule. We also want to cover messages for immigrants, things that you can share with the immigrant families that you serve. And I will also provide a number of resources at the end of the presentation. I would like to acknowledge our source material for this presentation. Much of our content has been adapted from the Protecting Immigrant Families campaign, as well as the Illinois Coalition for Immigrant and Refugee Rights Know Your Rights presentations. The information in today's presentation is current as of November 12th, 2020. Please know that there may be changes in the future to public charge, but the information you are viewing is current as of this date. And as I have already mentioned, this program is sponsored by a grant from Protecting Immigrant Families. Before we get started, it is helpful to review a few terms that you will see throughout the presentation. If you are familiar with government programs, you know that there are endless acronyms and abbreviations. For today's purposes, if I say DHS, I am referring to the United States Department of Homeland Security. The USCIS, or United States Citizenship and Immigration Services, falls under the umbrella of Homeland Security. USCIS is the agency that processes green card applications, as well as applications for citizenship and much, much more. Another term that you will hear throughout today's presentation is LPR. LPR stands for Lawful Permanent Resident. This is essentially an immigrant who has a green card, who has applied and received that permanent residency, meaning they are intending to remain in the United States permanently. A few other terms you may see: VAWA, Violence Against Women Act. This is a federal law that provides immigration relief to battered or abused spouses of U.S. citizens or LPRs. And then I don't know that we'll really talk about IDHS today, but just in case, stands for the Illinois Department of Human Services. This is the state agency that processes applications for Medicaid, SNAP, and cash assistance. So to get started, what is public charge? We've heard so much about public charge, in the last 2 years. And what we have found at Protecting Immigrant Families Illinois is that confusion persists about exactly what this rule is and who is affected by this rule. So we thought it would be helpful to start off this presentation by acknowledging the fact that public charge is not a new rule. It is not a new law. It's actually been part of immigration laws in the United States dating all the way back to 1882. And essentially, public charge allows the federal government to deny admission or to deport immigrants if they are found likely to need public benefits or public support, government support, to meet their basic needs. Now, today we are talking specifically about that admission piece, right? It's public charge on the grounds of inadmissibility. And you'll see why that's important a little bit later. If we think back, though, historically, or if we look at the record in the United States, how immigration officials have kind of interpreted or applied this law in the past, we've heard a lot about keeping out Mexicans at the southern border. But even in the past, when you had all those refugees fleeing Europe during World War II or in the lead up to World War II, public charge was applied even then. So this is not a new rule, but the current administration has made some significant changes to it, and we'll talk about that today. It is critical to understand when exactly public charge comes up. So when may immigration officials really consider public charge or kind of do an assessment for this? And essentially, public charge is a consideration when a person applies to enter the United States. So they are living abroad and they are applying for a visa to enter the United States. It also applies when a person is seeking to adjust their status. They are seeking to become a lawful permanent resident. Essentially, they're getting their green card. And then for persons who already have a green card, who have that lawful permanent residency status, the only time it will apply to them is if they leave the United States for more than 6 months consecutively. And then upon re-entry, they could be subject to public charge. So you will hear me mention that again throughout the presentation, and it's really critical that we understand that if someone already has a green card, there is no further public charge assessment unless they leave the country for that length of time. And so we'll often advise immigrants to consult with an immigration attorney if they have questions about being gone for that long. So just as it is important to understand who is impacted by public charge, it is just as important to understand who is not affected by public charge. And so you see on this slide a number of immigration statuses that are not subject to public charge. These are often humanitarian statuses, not always. And these are statuses that Congress has identified as exempt from public charge and therefore could not be changed through the administrative rulemaking process that yielded this current public charge rule. So, public charge does not apply to green card holders who are applying for citizenship. Very important to understand that. Coalition members have heard numerous questions about this population. So you can clearly say that if you are a green card holder, you are going through the naturalization process, there is no public charge determination made at that time that they are applying for citizenship. The other immigration statuses that are not subject to public charge include refugees and asylees, those VAWA self-petitioners, U or T visa applicants or holders, These U or T visas are provided to survivors of domestic violence, human trafficking, or other serious crimes. There are also special immigrant juveniles who are excluded from the public charge assessment, and other certain parolees. So there are a number of statuses that are not subject to public charge. And if someone is unsure of whether or not their status is subject to public charge, it is recommended that they consult with an immigration attorney or an accredited representative who is authorized to provide immigration advice. So when we think about this public charge on the grounds of inadmissibility rule, who really is most affected by this rule? And what we know is that this rule has the potential to drastically change family-based sponsorship or family-based immigration. So for those immigrants who are seeking their green card, they are seeking to apply for LPR status because of a family relationship. These are the folks who are most likely to be subject to public charge. And to be clear, it is only direct family members who can sponsor other family members into the United States. So if the sponsoring relative is a U.S. citizen, they're able to sponsor their spouses, children, as well as unmarried adult sons and daughters, and parents. So it's very strict in terms of who can sponsor someone into the United States. And we know that approximately 2/3 of the non-citizens who are seeking LPR status every year, they base it on a family relationship. Some immigrants may be sponsored by an organization for humanitarian reasons or by an employer. But we know 2/3 of the 1 million non-citizens are immigrating to the United States based on a family relationship. We thought it would be helpful to start at the beginning of this presentation just to kind of talk about some of those questions that we as coalition members have heard. So I already alluded to this, but will public charge affect immigrants who are already green card holders or who are already U.S. citizens? And this is a really, this is a clear-cut answer. This rule does not impact immigrants who have gone through the naturalization process and are now considered U.S. citizens. Once they have their citizenship, they are considered U.S. citizens. Also, for green card holders or those LPRs, right? Remember, they are not subject to public charge if they are renewing their green card or if they are applying to become a citizen. They are not subject to public charge. When it comes to renewing their green card, the card itself is usually good for 10 years, and then they have to renew and get a new card. But it's not like their LPR status goes away if they don't renew that card. You've heard me say it before. You'll hear it here, and you'll hear it again before the end of the presentation. The only time a green card holder is subject to this rule is if they are leaving the United States for a consecutive 6 months or 180 days or longer. That is the time that they could be impacted when they come back. So why do we care, right? What is the legal consequence of being determined a public charge? So we care for a lot of reasons, but there are actual legal consequences if someone was likely to become a public charge. And so if immigration officials determine that that person is likely at any time, not just now, but even at any time in the future, to become a public charge, they can actually deny admission to the country, or they could deny that application for a green card. They could deny that LPR status. And then depending if that immigrant does not have another status that allows them to remain lawfully in the United States, essentially that starts the deportation process, or they'll have to leave or they'll be deported. We also thought it would be helpful to note that just to understand a little bit about who processes these applications for green cards. And from within the United States, it's that USCIS federal agency that processes green card applications. But if it is an immigrant who is outside the US and going through the consular processing, it's actually processed by the US Department of State. And this is important because, the public charge rule I'm talking about today really is impacting USCIS under the Homeland Security rules. So what is the current status of the rule? There's been a lot of back and forth, and I'm not going to take the time to go into all of the timeline or all the details, but just know that as of February 24th, the public charge rule was in effect in all 50 states in the country. There had been several lawsuits filed, including one here in Illinois. And for a while there, Illinois was thought to be not having to go be subject to public charge, but essentially through the various different litigation steps, indeed it did go into effect on February 24th. So this date is important because any green card application filed on or after February 24th is subject to the new version of the rule, which we'll get into greater detail in a moment. Now, litigation continues, and you may have heard recently there was a big win here in the Illinois case, but then within a day later, another court, the Seventh Circuit Court of Appeals, actually stayed that ruling that was a victory for immigrant advocates. And what staying the rule means is that USCIS can continue to apply the public charge rule while the litigation continues. So there was no decision on the merits of the case. It was rather at the appeal level. It was just saying in terms of process that USCIS can continue to apply this public charge rule while the court cases continue. And so that's why, this information may change. Litigation continues. The fight is not over. But the reality is that green card applications submitted today in November will be subject to this public charge test. And without going into great detail, with the expected change in the presidential administration, there's been a lot of questions. Well, will the Biden administration be able to do anything right away? And we have to keep in mind, this was administrative or executive rulemaking process. And so it's not like they can just quickly repeal it. They would have to file a new rule. There's some other maybe procedures that could happen. So it's really important that the litigation continues. And we'll see what happens, over the next several months with those court cases. So for now, we do have to deal with public charge. And there's decisions that immigrants, may have to make around when to file an application for their green cards. But that kind of gets outside of the scope of today's presentation. And I think the takeaway, again, just to emphasize, is that as of today, this rule is in effect in all 50 states. Just a couple of other aspects of public charge, not so critical at this point, but just a quick review. There had been an interim rule in place with the Department of State. Remember, I mentioned that those LPR and visa applications that are processed outside of the United States are done by the Department of State. And so they had their own interim rule, which was issued back in October of 2019, but that is currently blocked by federal court order. So, if someone applies for a green card abroad through consular processing, they're using different rules than what USCIS is using here today. Also, there had been a White House proclamation also issued in October of 2019, which is also currently blocked by federal court order, which was going to require immigrants who were seeking visas and wanting to enter the United States to show that they had private health insurance, or that they were able to purchase private health insurance within 30 days, or have the resources, having the income or private means to be able to cover any health costs. That proclamation was blocked by a court order as well. And then Department of Justice, I hesitated whether or not to keep this in the presentation, and I'll just go ahead and mention it. Over the last few months, immigrant advocates had reliable information that there had been a rule circulating internally within the government and within Department of Justice about a possible rule about public charge, but really that would be based on deportation. Again, this rule we're talking about in today's presentation is about inadmissibility, but the DOJ was looking at a potential rule regarding deportation on public charge grounds. There had been no leaked memo, no leaked draft like there was with the Public Charge on Inadmissibility Rule. And there were a lot of advocates who were worried that it would be filed for the rulemaking process in advance of the election. And as of today, that rule has not been published, so, it may now just go nowhere. It's hard to say. So, we mention it just in case, because down the road, if that was filed and were to go through that process, we would, of course, want a lot of public comment to be filed, and then there would be more training. But as of now, that's kind of a non-issue as of today. And if something were to change in the next, several weeks, advocates would certainly get the word out.